Thanks for joining this episode of our webinar series on best practices in eDiscovery and digital forensics. I'm excited for today's session, not only because it'll deliver some sage advice, but our guest speaker is also very entertaining. I know you're going to enjoy it. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexby, and I'll be the moderator for today's event. We've got a lot of information to cover, so I'll jump right in. Our webinars take place monthly and cover a variety of relevant eDiscovery and digital forensic topics, trends, best practices, and strategies. We've got limited seating, so be sure to register early for the sessions that are of interest to you. If you have technical issues or questions, please email webinars@lexby.com and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com or on our YouTube channel, so you should follow us there and subscribe, and you'll be notified of new webinars as they're posted there. If you have any questions during today's session, please enter them in the Q&A portion of the GoToWebinar console, and we'll answer them after the event. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. For more than 17 years, Lexby's been helping legal teams with limited resources handle document-intensive matters. We have the industry's most affordable and full-featured DIY cloud-based eDiscovery platform. This includes over 7 different artificial intelligence algorithms. We have the industry's fastest eDiscovery processing and document review platform. And this is really important because this gives you more time to build a stronger case. And we heard this recently from a client who was having big issues with relativity in a document-intensive matter where the documents would render on the screen, but they couldn't get the coding panel to render on the screen, and they were only reviewing 3 documents an hour. We were able to help them solve these issues. We also deliver the industry's fastest return on investment, and we're rated as the eDiscovery company that's the easiest to do business with, a high performer, and the easiest to administer. We have a full forensic lab staffed with Cellebrite certified forensic investigators who perform full and targeted forensic collections as well. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled. Joining us today is Doug Austin. I'm going to let Doug introduce himself and eDiscovery today. But before I turn it over to Doug, I'd like to ask for your participation in a couple of polling questions. Our first polling question is, in what percentage of your cases do you utilize a dedicated project manager for eDiscovery? And while you're answering that, I'd like to thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And our next question, what percentage of your cases do you consider document intensive? There are a couple more answers coming in. All right, and I'll go ahead and close that poll. And without further ado, I'll turn it over to Doug Austin. Doug?
Well, thanks, Jeff, and welcome everybody to the Lexby webinar, 10 Tips for Better eDiscovery Project Management. I'm excited to be presenting here today, and I hope these tips are informative, and we're going to have a little fun as well, so I hope you enjoy it. Just a little bit about myself and eDiscovery Today. As you can see there in the second bullet point, eDiscovery Today is a daily blog about eDiscovery and related topics. As you can see there, cyber, data privacy, and so forth. Like I say, it's a daily blog. I've been blogging daily for almost 13 years, so I'm either committed or I ought to be. And you can certainly catch us at eDiscoverytoday.com, all one word, no dashes. I'll also mention that I've been in the industry over 30 plus years, so I have that background to speak from when I'm talking about project management best practices. So we'll go ahead and get started. Before we do, I do always remind people that any ideas expressed by me here today are my own, not those of my organization's clients or partners. But I also want to go a bit beyond that and say I'll be covering some cases that involve political or controversial topics. I'm not taking any position on the topics, merely covering the eDiscovery considerations about them. Also, please don't consider anything I'm saying legal advice. It's eDiscovery best practices advice. So please keep that in mind. One last thing I'll mention is that these slides have numerous links to resources that you can use to check out the resources on your own. So I encourage you to do that when you get a copy of the slides. So on to the first tip, which is don't fail to plan or you'll plan to fail. Projects have 5 phases to them, known as the 5 process management groups. And what do you know? Projects have a beginning, initiating and planning the project, a middle, executing and monitoring and controlling, and an end, closing the project, and each of these phases have to be effectively managed. And there are 10 project management knowledge areas that need to be managed as well, many of which we'll cover in subsequent tips that really encompass every aspect of a project. So when you put 5 process management groups together within knowledge areas to manage, you get a nice matrix like this with several activities associated with each. And where do most of the activities fall? In the planning process group. Just as Sun Tzu said, battles are won before they're fought because of planning, you could say that projects are more likely to be successful with well thought out upfront planning. So keep that in mind when it comes to planning your own project. Of course, it helps when we relate this to eDiscovery, and when we consider planning from an eDiscovery standpoint, there's actually a rule that promotes planning in coordination with opposing counsel, Rule 26F, known as the Meet and Confer Rule. Section 3 of that rule covers putting together a discovery plan to address considerations on how discovery is conducted. As you can see there, everything from timing to the subjects on which discovery may be needed, issues on disclosure, discovery, preservation of ESI, privilege claims, limitations on discovery, and so forth. So it's really a guideline to help parties plan discovery. And one of the most popular ways to document the discovery plan is the creation of an ESI protocol. An ESI protocol memorializes agreement on a variety of discovery considerations, and they become quite popular in litigation cases. The considerations include things like the definitions of terms, who the custodians are and how they'll be handled, what's expected from the parties regarding preservation, and what's not required to be preserved, such as inaccessible data on legacy systems or media, and system files. Scope and manner of collection, including whether forensic collection will be required. All parameters for forms of production, including images, native files, unstructured and structured data, such as information in a database, and hard copies. A detailed list of metadata fields to be included with the production. Things like how redactions will be handled and logged, including image and native redactions. Assertions of privilege and privilege logs, Bates numbering and confidentiality branding. Scope of deduplication, such as whether you're deduping globally or within custodians. Defining parent-child relationships, which has been an important one recently, including whether linked files from cloud-based Office suite sources, such as M365 or Google G Suite, are treated as attachments. How to handle and or document exceptions like password-protected files and corrupt files that can't be processed. Search methodology and use of TAR, where the level of detail here can vary widely. Some parties may even agree to include search terms in their ESI protocol, others may not. Production methods and timing, which includes how productions will be delivered, such as via encrypted hard drive, FTP transfer, and how rolling productions, if applicable, will be handled. And plans for identifying knowledgeable eDiscovery experts as liaisons to negotiate ESI issues going forward. It's very important to have an expert to help with ESI issues in your case, including the preparation and negotiation of the ESI protocol itself. Kelly Trigger's excellent eDiscovery Assistance site published a terrific 9-part series on ESI protocols, which covers many of the considerations of the items you see above. So I recommend you check that out via the links below. So here's a case where the defendant didn't plan thoroughly enough before agreeing to an ESI protocol. The ESI protocol stated that Hyperlinked files must be produced as separate attached documents, but the defendant found that doing so was very difficult and they had trouble meeting their production obligations. Judge Hickson here stated, litigants should figure out what they're able to do before they enter into an agreement to do something. Litigants should live up to their agreements, especially when they are embodied in court orders, as the ESI protocol is here. So lack of proper planning up front before entering into the ESI protocol put the defendant in a bind in this case. So, as the tip says, don't fail to plan or you'll plan to fail. Our next tip is remember the triple constraint of project management. All projects are carried out under 3 specific constraints. Traditionally, they're what you do and how well you do it, how long it takes, and what it costs. These 3 factors, commonly called the triple constraint, are represented as a triangle because they're interrelated, with the idea being that projects must be delivered within cost, projects must be delivered on time, and projects must meet the agreed scope. So, if the scope increases, the time or the cost or both must also increase. Or, if the budget's reduced, the scope must also be reduced, or the deadline may need to be extended, or both. The typical saying for a project manager to set client expectations is to say, you can have it fast, cheap, or good, pick 2. It's important to keep that maxim in mind when working with clients and setting and managing expectations, because you'll invariably work with a client that wants to push the envelope on all 3, and ultimately at least one has to give. Here's the next tip, and let's face it, when you're a lawyer and you find out that you've inadvertently produced client confidential information in litigation, that's a bad day. When you find out that confidential information is personal information on thousands of the wealthiest investors in your client's portfolio, it's an even worse day. And when you find out that disclosure is being covered by the New York Times, it's a lawyer's worst nightmare. In this case, the lawyer working for an outside counsel firm representing Wells Fargo inadvertently produced tens of thousands of client names, social security numbers, account balances, and more. In a surprisingly frank affirmation filed with the court, she described how the inadvertent disclosure evidently happened. She mentioned that she used the vendor to conduct a search of email and used the vendor's eDiscovery software to review the results, marking documents as confidential or privileged. So far, so good, right? Here's where it went wrong per the attorney's statement. Unbeknownst to me, the view I was using to conduct the review had a set limit of documents that it showed at one time. Thus, I thought I was reviewing a complete set when in fact, I only reviewed the first 1,000 documents. In other words, she didn't know enough about the software to realize that she had to advance to the next page or check out another batch. Was she improperly trained, or did she not pay attention during training? We'll never know. She also said, in addition, it was my understanding that the vendor was going to apply redactions for documents I flagged as needing redactions. Thus, I thought that responsive documents that contain confidential information would be redacted prior to production. How she expected the vendor to know what redactions to apply and where simply based on a needs redaction tag, I have no idea. I guess mind reading is a skill she thought the vendor needed to have in this case. She sums up the issue perfectly by stating, I realize now that I misunderstood the role of the vendor. Gee, you think? So certainly the lawyer makes some mistakes here in not understanding the technology and not understanding how to use the eDiscovery software, but the vendor should certainly be held accountable as well by not providing certain checks to help ensure that all documents were reviewed for confidentiality and privilege, and not raising the issue that there were documents flagged for redaction that hadn't been redacted. A few simple QC checks from the vendor could have saved the lawyer here. Communication is key. And here's an example of an email on the right-hand side of the slide that I would typically send to a client when I'm asked to perform searches where I clearly communicate how many potentially responsive documents there are. I even underlined it twice to emphasize it. Not only that, I typically try to follow up with a phone call to ensure that the attorney has received the message and clearly understands what they have and address any questions. I like to employ this belt and suspenders approach to communications with clients as much as possible by discussing requirements or issues with the client and then following up with documentation to confirm the understanding. Or sending them an email with important information and then following up with a phone call to make sure they saw the email and don't have any questions. We all get so many emails these days, it's easy to miss important ones. So you want to make sure to follow up and confirm you're on the same page, literally. If no one's driving the bus invariably ends up in a ditch. So our next tip is read the rules, Shankopotamus. My colleague and friend Tom O'Connor says this all the time, referencing the E-Trade baby commercials from a few years ago when talking about the importance of understanding the rules. And here are some of the most common rules you need to know. Now, you may be thinking, knowing these rules is the lawyer's job, and it is, but still, as a project manager, you should know them too. And as I mentioned, here are some of the most common rules to know and links to them. There's a database full of court rulings involving lawyers who didn't read the rules, Shankopotamus, and I cover 60 to 70 cases a year involving those mistakes. So what happens if you don't read the rules? Your client could become this guy. His lawyer inadvertently produced his entire cell phone history over 2 years and failed to properly claw it back within the 10-day window allowed by Texas Rule of Civil Procedure 193.3D, which meant opposing counsel could use it to show that Alex Jones lied when he said he didn't have relevant text messages related to Sandy Hook. Karma? Maybe. Nonetheless, it's important to read the rules, Shankopotamus. One of the most important rules to know is Rule 1.1 on competence from the ABA Model Rules of Professional Conduct. Several years ago, they added language to Comment 8 that competence also requires understanding the benefits and risks associated with relevant technology and staying abreast of changes in it. Not only that, but over the past several years, 40 states have now updated their rules to include a technology competence requirement. Bob Ambrogi's Law Sites blog, as you see the link in the lower left-hand corner there, keeps track of the states and provides a link to each of those rules changes you can check out. Technology competence is very important for the entire legal team and especially important for the project manager. So the next tip is get a clue about your stakeholders and what motivates them. Earlier, we discussed stakeholder management as one of the key knowledge areas to manage. There can be a number of stakeholders in any eDiscovery project, and they can involve multiple organizations. I recently managed a project where the company I was working for at the time was providing services to another service provider, which had a corporate client and needed to coordinate with that client's outside counsel firm. In turn, we had a provider partner providing some additional services. As a result, we had 5 different organizations represented in some calls to discuss how to proceed with discovery. And this isn't uncommon. So I'm going to have a little fun, and I'm going to represent the different types of stakeholders as characters in the board game Clue. As you can see on this slide and on subsequent slides, I prefer the old school version of the game. I'll talk about each of them, what motivates them, and how to make them happy. Pay no attention to the gender of each character, as each stakeholder type could be any gender. So here's the first stakeholder. It's the lead attorney in the case. It's Mr. Green, of course. Get it? Green because he or she is focused on billable revenue. And also because with regard to technology, he or she may be a little green. Not only is the lead attorney focused on billable revenue, Mr. Green is also focused on meeting deadlines and production obligations. So you can make Mr. Green happy by providing useful information as early as possible for decision making and helping him meet those deadlines. Next, we have the supervising review attorney. Which clue character fits best here? That would be Mrs. White. Mrs. White has a lot to coordinate to make sure that the review of documents doesn't wind up being half-baked. She or he has review deadlines to meet and wants to avoid some of the eDiscovery disasters that we've been covering and will continue to cover during the course of this presentation. And so good, timely information to make key decisions and support to keep the workflow moving will make Mrs. White happy. By the way, sometimes the lead attorney and the supervising review attorney are the same person, but other times they're different people, and they need to be on the same page to ensure a successful result. Next, we have the litigation service provider. Who to use here? How about Ms. Scarlett? People who become LSPs often start out as paralegals or IT people in law firms and develop a career as an LSP from that. And by the way, in this case, we're talking the external litigation service provider, not an internal litigation support person. The LSP wants to be helpful, wants to identify opportunities where she can help, and she or he needs clear directions to ensure quality delivery of services. Also, Ms. Scarlett works better when working with you as a partner, not as an order taker. She has certain expertise that you should take advantage of to ensure a successful project outcome. Next, we have the eDiscovery software provider. Mrs. Peacock prides herself on her appearance and an intuitive UI without, of course, putting lipstick on a pig. And she wants to know what you need from her to make her product better. She also wants for you to attend the software training she's willing to provide and actually pay attention during the training, or you could miss important information about how to use the product effectively, which could cost you down the road. While I've represented the LSP and the eDiscovery software provider as separate people, sometimes they can be the same person or at least from the same organization. Regardless, there are services that accompany any software platform, such as training, support, and product management, and Mrs. Peacock also wants to work with you as a partner to make sure you get the most out of the product. You'll find out what happens when you don't take advantage of these services in a bit. Next, we have the technology specialist, and of course, that's going to be Professor Plum. Professor Plum thinks he's smarter than we are, and he's probably right, at least in some areas. He or she has unique skills that can add value in specific instances. Examples of people in our industry who fit that bill are people like Craig Ball with forensics and collections, and Maura Grossman with technology-assisted review. There are excellent examples of somebody that has the skills to provide unique advice and guidance that few can offer in that field, and even serve as a special master to assist the court in that regard. You may not need Professor Plum on every project, but it's nice to be able to rely on that expertise when you do. So you want to keep an open mind and embrace the use of technology to improve processes and workflows. And finally, you have the most important stakeholder of all, the client, which in this case is Colonel Mustard. After all, it's the client is the one who's paying for all this work. Clients want to see projects completed on time and on budget, and they want to avoid embarrassment through sanctions or inadvertent disclosures of sensitive materials. You want to provide them with timely information to make informed decisions and guidance throughout the process so they know what they're paying for. So there you go, 6 stakeholders that you may need to work with on your eDiscovery projects. So you want to understand what they need to make sure that their success is aligned with your success in managing the project. So our next tip is about testing your searches. And here's a case from a few years ago from my home state of Texas, where the parties negotiated search terms. 2 of the terms are what you see here. That exclamation symbol is the wildcard character in this case, and the /10 means within 10 words of. So clearly it looked like the parties chose to add a wildcard to app to search for app, apps, application, or applications. Makes sense, right? However, there are more words in the English language that begin with app. So how many are there? There's this many. And this many. And this many. 308 words that begin with app, and 304 of them are bad. Apparently, it appears the application of the wildcard was appealing when it was an approximate or even appropriate. It was appalling. See what I did there? This is known as getting wild with wildcards, and it's one of the most common searching mistakes I see legal professionals make. A much better search would have been to break out the individual term with or separators to be much more precise, as you see in the example here. The example isn't perfect because they were inconsistent with their wildcard on phone and smartphone, but we won't quibble. Keep in mind, the parties negotiated this awfully overbroad term, so neither of them realized just how bad a search term it was. Fortunately for the defendants, Judge Andrew Austin, no relation, ruled that the defendants weren't required to produce everything responsive to the search results like the plaintiff wanted. They still had the right to review them, but they had to review a lot of extra documents they wouldn't have had to review, which probably was punishment enough. By the way, you might be wondering what kind of nerd knows there's 308 words that begin with app. The answer, Scrabble players. who use the site more words to identify words they can use. It's not just good for them, it's also great for testing wildcard terms. So as you can see here, you can do starts with and ends with searches to see what a wildcard might retrieve and avoid using those wildcards that are over-inclusive or maybe even under-inclusive. I provided links to examples for a starts with and ends with search at the bottom of the slide there, where all you'd have to do is substitute in the stream you want to look for, and you could run your own searches. A very simple web search that would have probably taken about 20 seconds to type up here could have literally saved thousands of dollars in unnecessary review time. So let's look at some more bad search terms, this time from the January 6th attack investigation. Again, this isn't a political discussion. It's focused on the search terms, which are really bad here. I found Democrats and Republicans are equally able to be totally inept when crafting search terms. Here are some likely under-inclusive search terms. In the second example you see there, we see a wildcard that actually isn't wild enough. The placement of it leaves out at least one form of the word. They leave out the ing form of the word there. So wildcards can be under-inclusive as well as over-inclusive. Of course, they can also be over-inclusive here as well. And in addition to over-inclusive wildcards, we've got some other terms that were likely over-inclusive as well. The names of 7 states that are terms by themselves. That red and is an indication of that just being to show that there were 7 unique states there. I don't think every document mentioning any one of these states is necessarily relevant. Not every document mentioning Arizona is relevant, and so forth. Certainly the last 2 on these slides are more examples of wildcards getting wild. There are 127 words that begin with GAM, and there are 74 words that begin with RIG, and most of them don't have anything to do with war games or rigging the election. When you gamble on search terms, you're just not right. And this may be my favorite common mistake, what I call the Department of Redundancy Department search. In the first example, they have 4 searches that are specific proximity searches, but then they add a superset term, election, that makes the other 4 searches irrelevant. The second example uses 4 specific government websites, but then adds the superset .gov, which not only gets other federal government sites, but also picks up state and local too, which is as many as 5,300 possible websites. I could be wrong, but I don't think too many of them have anything to do with the presidential election. So this next slide illustrates the first example. You all remember the Venn diagram and unions and intersections, right? The wildcard term of corrupt combined with the wildcard term of election with a proximity of within 5 words yields a nicely specific search, in theory at least. But when you add the superset term, that term and the other 3 terms get swallowed up by it. As a result, these 4 searches are essentially rendered irrelevant. Unless the reasoning is to simply find out the number of documents responsive to these searches, this combination of searches just simply doesn't fit well together. One great way of identifying search terms that might be overbroad is to run a search term report and determine the unique hit counts for each of the searches. Here's an example search term report from Lexby. A search with multiple terms is often derailed by a single overbroad term. I once had a search proposed by a client where 2 of the terms were simply India and China, respectively. The search term reports showed how those terms added numerous unique hits with documents only mentioning either or both of these terms and no other term, showing those terms were overbroad and needed to either be removed or limited using other qualifiers. So a search term report can help flesh out those overbroad terms. Of course, the best practice for determining whether a search term is properly scoped is to test it. Now, if you're a lawyer out there, I know you're probably thinking, they said there would be no math. But you don't need to actually know math or break out a statistics book. All you need to do is input 3 numbers into the right side. Here are the 3 things you need to know: the size of the test set, the confidence level, and the margin of error. The size of the first test set will be the number of documents retrieved by your search, but you'll also want to test the documents not retrieved, which is known as the null set, to see if your search is missing relevant documents as well. So you'll typically have 2 sets of documents to test. An appropriate confidence level is typically either 95 or 99%, and an appropriate margin of error is typically 5% or less. Typically, 5% is fine. And the end result is you don't really have to sample that much to obtain an acceptable statistical sample. If you have a search that retrieves 100,000 documents and you want a 99% confidence level with a 5% margin of error, you'd only have to review 662 documents to get that. It's even less if a 95% confidence level will do. Only 383 documents need to be reviewed. For the 1 million documents not retrieved, you hardly have to review much more for a much bigger document set. Only 666 and 385 documents, respectively. And here's a site that enables you to calculate the sample size you need. Simply input the confidence level, margin of error, and population size. You can leave the population proportion alone. It typically can remain at 50%, and you'll get the sample size you need. It's easy peasy. It's just like using a calculator. And if you're spooked by the 666 number, maybe the 95% confidence level is better suited for you. And here's a site that enables you to generate random numbers from your random sample. So you enter the size of your random sample, the start and end of your range, typically from 1 to the size of your document set, how many columns you want the results in, and then you press the Get Numbers button. And the second screenshot there shows you'll get a list of randomly selected numbers, which can be record numbers in your set to be reviewed for the test. By the way, that's why I selected one column. It enables me to paste those results into an Excel sheet and sort the list. And once I do, voila, I have a list of document IDs I can retrieve from my random sample. So hopefully this illustrates just how easy it can be to create a random statistical sample for testing your searches. So our next tip is understand the evidence and how to use it. Here's Rule 34B, which discusses form of production. It gives the requesting party the right to specify the forms in which ESI is to be produced, which is a very important right not to take for granted. It also gives the producing party some rights and responsibilities as well, including producing documents as they're kept in the usual course of business, producing it in a form or forms in which it's ordinarily maintained, or in a reasonably usable form or forms, and not having to produce the same ESI in more than one form, which means no do-overs for requesting parties if they didn't specify the form they wanted it in the first place. So let's talk about the importance of form of production and how metadata enhances the form in which it's produced. And I'm sure you recognize this case from last year. Let's face it, when an eDiscovery professional walks by the TV and sees metadata expert testifying on the screen, it's like a dog seeing a squirrel in the yard. You know, I had to stop and check it out. And that was the case last year when my wife, I swear it was her, was watching the Amber Heard Johnny Depp trial, and I saw a metadata expert testifying about Amber Heard photo metadata. Again, I'm not taking sides here, just pointing out a forensic analysis. The expert observed in his testimony that the software associated with the first photo of bruising on her face shows Photos 3.0, a photo editing software program, instead of the iOS version associated with the iPhone 6. This indicated that the photo was saved in an editing program. That doesn't prove 100% that the photo was edited, but it's not a good look. If the photo wasn't edited, the attorney should have produced the original from the iPhone 6, which would have confirmed that. The metadata accompanying the photo here enabled this analysis, which is why it's important to request native files with the metadata so that you have as much information as possible about the evidence being produced, especially in this area of potentially deep-faked evidence. By the way, the expert's name was Norbert Neumeister. He goes by Ryan, which is a shame because if there's ever been a better name for a forensic examiner than Norbert Neumeister, I haven't heard it. While there's some room for doubt in that last example, there's no doubt in this one. This was a case from 2021 where the plaintiff alleged that she was being sexually harassed by her supervisor, and she produced this image to the right, which looks pretty bad. It was first produced as a PDF and then as a JPEG file. She claimed that she'd received the messages on her iPhone 5, but because the phone had a cracked screen and ink bleed, she claimed she couldn't take a screenshot of the message from the phone itself. So she claimed that she took a picture of the text message exchange on the iPhone screen using an iPhone X, which seemed fishy because the image didn't show any screen cracks or ink bleed. It also didn't have any metadata that a picture from an iPhone X would have, and was determined not to be a photograph at all. But the clincher was the emoji she used. The heart eyes emoji depicted in the image is the version displayed on iPhones running OS 13 or later. The problem with that is that because she was using an iPhone 5, her phone supported only up to OS 10, which displays the emoji differently, and can't possibly display the version of the emoji she included in the image produced. This was literally the case of the smoking emoji, and Judge Coates stated in dismissing her case, this image is a fabrication. So here's an example of a photo with me and my lovely wife Paige with the Golden Gate Bridge in the background. So how can you be sure that this photo is legitimate and I didn't Photoshop it? And what's up with that cap I'm wearing? And why do I have such a big smile on my face? The photo metadata can answer all those questions. Here's just the metadata that's displayed when you push upward on a photo in an iPhone. It shows the date and time the picture was taken, the type of phone, and other picture parameters, including that it's stored in HEIF, high efficiency image file format, which Apple uses to compress images so that they don't take up as much space, and the geolocation of the photo, which proves it was taken at the Golden Gate Bridge. As for the hat and the big smile, the date was the day after my Houston Astros won the World Series. You didn't think I'd forget to mention that, did you? It's also important to note that metadata is useful in many file formats, not just photos. It can tell you whether emails have been opened in Outlook. It shows formulas in Excel, and it shows track changes and comments in Word, and much more. So you want to consider requesting native file productions to get the metadata, which can benefit your case. Another component of Rule 34B addresses objections, and it was added in 2015. It requires parties objecting to discovery requests to state with specificity the grounds for objecting to the request, including the reasons, and also to state whether any responsive materials are being withheld on the basis of that objection and permit inspection of the rest. An objection that states that the request is overly broad, unduly burdensome, disproportionate to the needs of the case, and not reasonably calculated to lead to the discovery of admissible evidence is considered a boilerplate objection, and courts are increasingly finding those objections are waived. Parties no longer get a second chance to object when using boilerplate objections. And here's a case that illustrates that, where defense counsel for the Illinois Department of Corrections eventually produced its entire production, a whopping 4 pages of documents, after which plaintiff's counsel speculated that defendant had either not conducted a good faith search or had destroyed documents. As Illinois Magistrate Judge Jeffrey Cole, who regularly has some pointed and entertaining observations, stated, once the charge of spoliation was made, things, to quote Ron Burgundy, really escalated quickly. While that's a clever line, what he said about the defendant's objections was more important when he said, first things first. Time and time again, attorneys are warned that boilerplate objections are unacceptable. They're tantamount to not making any objection at all. The boilerplate answer constituted a waiver of whatever objection, if any, IDOC might properly have made. Boilerplate objections, as we've shown, are ineffectual in all contexts. That's indicative of the type of responses that courts are making in response to boilerplate objections, so you want to avoid making them, otherwise you'll probably lose the right to object at all. So while we've been showing examples of how not to do things, here's a good example of how an objection should be made. In this case involving alleged overcharging for shipments and a request for detailed package-specific discovery for 5 years' worth of data, defendant UPS provided specificity in their response, explaining that the data was live for only a limited time and then archived on backup tapes. They provided an estimate of $120,000 just to restore the backup tapes. They also offered an alternative solution, providing an estimate of the number of packages for a 6-month period. Why 6 months? That period was selected because UPS's contract terms stated that a customer must give notice of a billing dispute within 180 days or the issue is waived. So in this case, Judge Whalen agreed with UPS that the request would be extraordinarily burdensome, and he ordered the parties to meet and confer. So that's an example of doing it right. So we've talked about the why you need to understand the evidence. Here's the what. This is the 2023 Internet Minute infographic created by eDiscovery Today and LTMG earlier this year. And it represents everything that happens on the internet in an average minute. Everything from 241 million emails sent per minute to 19 million text messages per minute and so forth. Even stats for things like Slack messages and Teams chats, Zoom meeting minutes, smartphone photos, fake Facebook accounts removed, and ChatGPT visits, which is probably already out of date since this graphic was created. All of that is potential evidence in litigation, so it's important to understand that evidence not just at the surface level, but also at the metadata level as well. And keep in mind that evidence is always changing, so your need to understand the evidence is always going to be changing as well. By the way, you can check out the link on the slide if you want to see where we got the numbers. Of course, all good PMs need to understand and embrace the technology, which is our next tip. eDiscovery Today conducts a yearly survey on the state of the industry, and for 3 years, we've asked a question about what percentage of cases are utilizing predictive coding. And you see the results here. 29.2% of respondents use it all or most of the time, while 35.4% use it little or none of the time. It's not exactly strong adoption. Even worse, the numbers are essentially unchanged over the last 3 years. In fact, the first of the 3 years was the highest level that we saw. So to that, I honestly have to say, come on, man. It's not that hard. Technology-assisted review has been around for more than a dozen years and court-approved for more than a decade. It's using the same machine learning technology you use in your Netflix, Amazon, Spotify, and probably many other accounts. And it's not only typically more efficient than human review, but it can be as accurate or even more accurate than human review as well. This is proven technology that your organization should be considering for your eDiscovery workflows. Still think that keyword search is easier to understand than TAR? This is just one of 26 searches in a case I covered last year. Can you tell what's going on there? I'm having trouble, and I've been doing database searches for over 30 years. Many legal professionals think they understand keyword search, but many don't understand it as well as they think they do. It's also important, per the technology competence rule we discussed earlier, to stay abreast of the latest technologies, as they're technologies that we'll need to be prepared to incorporate into our workflows in the future. So that includes things upcoming like large language models and generative AI technologies that are becoming much more prevalent since the release of ChatGPT late last year. Technology is always evolving, so we need to embrace that change as project managers. Next tip is to QC the bleep out of your productions. One QC check I like to perform at production time is to create a matrix starting with the files that were originally collected. Then you count the files that were exceptions, those that were duplicates, those that were filtered for other reasons, such as non-responsive domains, those that were not retrieved during searching as potentially responsive, those that were reviewed and determined to be non-responsive, those that were reviewed and determined to be responsive but privileged, and finally, responsive files that are being produced. These are the typical buckets that files fall in during culling, searching, and review. If the total of these counts matches the total number of files originally collected, great. If not, then something slipped through the cracks and you have to figure out where the mistake was made and correct it. If the Wells Fargo team had done that, they might have avoided that embarrassing, huge, inadvertent disclosure. Another important QC check is redactions. Here's some common redaction failures to avoid in eDiscovery projects, including failure to burn the redaction into the image, which is one that we see quite a bit. But in addition, you also have to watch out for failure to extend those redactions to the corresponding text and native files. I recently covered a case where the producing party handled redactions in the images just fine, but failed to extend the redactions to the other data forms being produced. You have to catch them all in QC so that you don't have to try to claw them back later. Every year there's a story or two in the headlines about people failing to apply redactions properly and letting that information get out, in many cases to be discovered by a reporter. And these next few figures, two figures, illustrate what can happen using a blog post I wrote. If you see the white space in the blog first screenshot, when you use the black highlight or white text method to attempt to redact text in a document, all you have to do is highlight the affected area to see the redacted text. The text is also searchable as well. You can go to the post via the link at the bottom of the slide and try it yourself. However, if you're using a review platform, an eDiscovery review platform like Lexbe, the redactions you make will be protected. Here's an example of a document which has been redacted with both a dark and a white redaction. When you're in the platform, you can still see what's being redacted as it's grayed out. But if you save the document out to a format like Adobe PDF, the redaction is burned into the image. This is the advantage of using an eDiscovery platform to perform redactions, and it's important to include a QC check of redactions as part of your checklist before production goes out the door. My final tip is know what done looks like. Here's the EDRM reference model, which is a framework on what eDiscovery workflows are established. Hopefully, you're already familiar with the EDRM model. This is an older version of the model. The newer version is the same, just prettier. It shows the IGRM model in place of that little circle that says information governance and so forth. But the model is essentially unchanged for nearly 20 years now. And here's the model again. Notice anything different this time? Yep, this version of the model is backwards. When planning for your eDiscovery project, it's often best to work backwards and start with the goals to be accomplished for the end phases and use that to guide your work at the beginning of the process. So for the ESI that you plan to present, you'll need to identify that ESI and determine whether it's in your possession or whether you'll need to request it from another party. And you'll need to determine what ESI you need to preserve and collect to meet your production obligations. Or maybe you'll need to determine what data you need to request from other parties as a part of that initial process. The volume of data that you expect may drive review decisions, such as how many reviewers you may need, or whether you should consider using technology-assisted review to conduct your ESI review. So by starting backwards and knowing what done looks like, you can plan for your activities through the life cycle of the case. When does this happen? In the planning stage, which takes us back to tip 1, where we started this discussion. So that's 10 tips for better eDiscovery project management. Last thing I'll mention is that these tips and much more came from these white papers, reports, and books. The first 3 are available free from eDiscovery Today. All you have to do to get them is to subscribe to eDiscovery Today, and you'll get them and any other report we publish. You can do so via the link in the lower left-hand side of the slide. The 4th item is Mike Quartararo's terrific book on project management in eDiscovery, which I highly recommend, and which you can purchase from him via the link above the book picture there. If you're serious about project management, you should check that out. So with that, I'll say thanks to all of you for attending. Hope you enjoyed the presentation, and I'll turn it back over to Jeff to close us out.
Thanks, Doug. Your best practices, examples, and delivery are always valuable and entertaining. We'll have to have you come back and do another session soon. Lexbe helps law firms and enterprises address forensic collections and eDiscovery. At Lexbe, we provide comprehensive remote and on-site forensic collections that are fully defensible. We utilize industry-leading tools like Cellebrite and Axiom Magnet. We handle a very wide range of device and account types, as you can see on this partial list. And now I'd like to ask our next polling question. Do you have a forensic collection project, and would you like a complimentary consult? All right, I'll go ahead and close that poll. With Lexbe's eDiscovery platform hosted at Amazon Web Services, you get on-demand capabilities that scale to address the needs of your case, no matter how small or how large, like we talked about that big case that was in Relativity previously. With Lexbe's cloud infrastructure, you can get from document ingestion to review faster and get your productions out the door faster. All of your remote or mobile connected employees can access the Lexbe eDiscovery platform via web browser Works great on Macs, PCs, iPhones, and Android devices. This gives you unprecedented flexibility and efficiency. I also wanted to point out on this slide that Lexbee is a single end-to-end eDiscovery platform. Unlike many eDiscovery providers, you don't have to move your data from one solution to another. Lexbee has fully integrated processing, document review, analytics, case timelining, artificial intelligence algorithms, and production capabilities. We easily handle the smallest of cases to the largest of cases and scale infinitely. As Doug mentioned, as a best practice, taking a belt and suspenders approach can help mitigate problems. At Lexbee, we've engineered a belt and suspenders approach into the platform as a safeguard to help prevent these issues that Doug used in his example. And here you can see an example of how we engineered belt and suspenders into the Lexbee platform with these production validation steps. We continue to innovate the Lexbee eDiscovery platform, which not only means your Lexbee subscription continuously improves, but we're also creating new efficiencies and pass the cost savings on to customers. That's why we don't have to charge you for processing, file promotion, early case assessment, user fees, OCR, productions. We don't nickel and dime you with electronic endorsement charges, and we save you money on the hosting as well. If you've got clients that are trying to cut their legal services spend due to the recessionary climate, then you should experience a demo of Lexbee. It only takes 10 minutes and you'll see what you've been missing. We give you more time to build a stronger case by getting you from document ingestion to review faster, and we help you get your productions out the door faster. David Jones was concerned that he would be outgunned by his AmLaw opposition. He quickly realized that Lexbee was a great equalizer and helped him build his best case that delivered a winning verdict. Paige Tackett at Thompson Co. needed Lexbee's speed to get some productions out the door to meet deadlines. Lexbee is lightning fast and gets you from document ingestion to productions faster. Patrick Biggins needed an easy-to-use eDiscovery platform to handle document-intensive cases for a boutique law firm. Lexbee got him onboarded in minutes and provided the support they needed to build a strong case. And with that, I'll ask our last polling question. Would you like a demo of the Lexbee eDiscovery platform? While you're answering that, I'd like to thank you for attending today's session. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of the Lexbee eDiscovery webinar series. For notices of future live and on-demand webinars as part of this series, please email us at webinars@lexbee.com or follow us on LinkedIn. We'd also like your advice regarding our webinar series. Please complete the survey at the end of today's session. It helps us continuously improve this program and cover the digital forensic and eDiscovery topics that are most relevant to you. And with that, I'd like to thank Doug for presenting today, and thank you for attending. Be sure to follow Lexbee on LinkedIn so you'll be alerted to the latest podcast and webinar episodes. And watch your inbox for an invite to our next webinar on best practices in eDiscovery and digital forensics. Take care.